Lord, may I be permitted to mention one matter? Your Lordship pleasure will be to recall on August 27, 2025, those series of walk-off matters your Lordship was deciding, wherein my Lord Mr. Naqib Ahmed was my Lord.
That is a chamber matter.
No, my Lord. And regular application.
So that is due to appear when?
It is due to appear on 24th.
24th
24th of this month.
Yes.
Now, my Lord, what has happened, Lordship, my Lord, I will only take 2 minutes of your Lordship.
Yes.
Your Lordship pleasure was to direct, my Lord, 2 special officers
Yes.
who went inquired into the affairs of the estate. Now, my Lord, what has happened that Najid's and Mutawali's both applications were there. Your Lordship, my Lord, has only directed against the, my Lord, the Mutawalis. Now, my Lord, we have taken out an application because that application was heard in my absence. Your Lordship will...
Anyway, I passed an order. Thereafter, you came.
Yes, my Lord, I filed an application also. That application's returnable date we have given in 5th. Only
anyway, let it appear. Thereafter, I shall see.
Only one, my Lord, indulgence.
Yes.
I will only, my Lord, bring it before your Lordship's notice that we will be praying for an, my Lord, deferment of date before the...
No. Let it appear on 24th. Okay. Let both the matters.
No,
have you taken out any application?
Yes, special officers are coming for inspection today.
Yes.
But I will only request them to wait till Wednesday.
No. Better not. Let it be done. Okay. Subject to the result of your application. If you want to give a slip, you please give the slip. Okay.
My Lord.
You give the slip, it will appear along with that 24th.
My Lord. Grateful.
You give the slip.
My Lord.
May I have your Lordship's leave to mention one matter on notice for inclusion in the list, my Lord. Execution application, my Lord. Chamber business may be taken up.
Item number 1. Call করে দিন।
Next matter at 10:30 a.m.
Number 1. My Lord, Mr. Surajit Nath Mitro has requested for not today. He has prepared, he would be taking some time and it, my Lord, 12 p.m.
No, Mr. Devottor is to conclude today.
Mr. Devottor has concluded. It was Mr. Mitro who had to...
I will add 1 or 2 lines further, but Mr. Mitro has to only give reply to that.
Yes.
Only on the point of law.
Mr. Devottor concludes, Mr.
Only
Mitro has
on the
to give the
point of
reply.
law, nothing else.
Anyway, then I am making it not today, just not today.
My Lord.
My Lord, I have no objection in asking the time,
So let it be
particularly on the ground of Mr. Mitro, a good friend
so
of
I
mine.
can fix it on some other day at 10:30.
But my Lord, may I make it clear that Lordship has heard this matter at length. It is only the reply to be given by my learned friend. And the reply is, my Lord knows that reply is only on the point of law, not on the further argument on the fact.
Yes.
So therefore, my Lord, if they want to give reply only point of law, they can give it.
It has to be concluded on the same day. Your submission and Mr. Mitro's reply. Entire thing has to be concluded on a particular date.
My Lord, as I
am fixing the matter.
My Lord, Mr. Devottor has concluded.
No, I will conclude. I will conclude.
Achha.
My Lord, let it be not today, let it be there tomorrow.
I'm fixing it at Friday. No, tomorrow is a chamber day, so...
at 2 p.m., my Lord?
No, 2 p.m. also there are other matters.
Lordship can check the
personal difficulty on Friday.
PM.
Either on Thursday or Tuesday, my Lord.
No, coming Monday.
Coming Tuesday.
2 p.m.
Coming Tuesday, then again that problem chamber day. So it cannot be taken up.
Well, day after tomorrow in that case.
Day after tomorrow?
I have no problem.
Achha. Let this matter appear. Hey. Achha, day after tomorrow at the top.
My Lord.
Let this matter appear on 17/9/2025 at 10:30
For the
a.m.
purpose of reply.
Yes, under the same heading.
Under the same heading.
Under the same
Yes, because after you conclude, Mr. Mitro will conclude on the same day.
No, my Lord, conclusion is definitely Mr. Mitro will do. But the conclusion is only by way of reply.
Yes.
That make it the way I make it.
After opposition, it is reply only.
Only reply. That's right. Only on the point of view.
17/9 আছে 10:30.
Item number 6.
Item 3. Item? Huh? Item 6, okay, not today. Make it not today only. Others say, "Bhai, ye to nahi, parties de nahi to."
Item number 7.
My lord, led by Mr. Gautam Chakraborty, my lord, in this matter, my lord, your lordship passed a direction in the last occasion, my lord, to serve the copy of the cause papers upon the learned advocate who is representing before your lordship, my lord, through my lord, Legal Services Authority, High Court, Calcutta. I have already given, my lord. And thereafter, your lordship also directed us, my lord, to make a compilation of the entire orders, my lord. We have collected the entire set of orders, my lord. It will be more than, my lord, 300 copies and more, my lord. We are trying to resolve it, and in the meantime, my lord, we make a compilation of that orders, my lord. Let a date be fixed, my lord, after puja vacation for hearing of the matter, my lord.
The hearing of?
Hearing of the matter, because, my lord,
No, that
this lady will
compilation, I
give.
have to see that compilation.
Yes, my lord. Yes, my lord. In the coming day, my lord, I will submit the copy of the orders with compilation, my lord.
Record an order. Both items 6 and 7, same order. Learned advocate, 7? Okay, 7 to 9.
Yes,
Same
ma'am.
order hobe, huh?
Yes, ma'am.
Learned advocate for Nitai Chandra Barik and Joyaboti Barik in person are present. Learned advocate for Nitai Chandra Barik prays for time to submit the compilation.
My lord, only one thing, legal heirs of Nitai Chandra, because my Nitai Chandra Barik already died, my lord.
Learned advocate for legal heirs of Nitai Chandra Barik. ঠিক আছে নিতাই চন্দ্র না না আচ্ছা আর একটা ঢুকে দেবেন যে লার্নেড অ্যাডভোকেট ফর নিতাই চন্দ্র বারিক and Joyaboti Barik in person and learned advocate engaged by the State Legal Service Authority.
Well,
Are present.
amicus curiae me upon
Yes, yes, State Legal Service Authority acting as amicus curiae is also present. On the prayer of learned advocate for the heirs of Nitai Chandra Barik. The heirs of Nitai Chandra Barik have been substituted.
Yes, my lord.
They have been brought on record.
Yes, ma'am. In which matter? একটা suit হয়েছে না?
My lord,
There are two suits.
everywhere.
Yes. Prays for time to submit the compilation and the list of dates to proceed further with this matter. Thus, this matter stands adjourned till 3/11/2025 for under the same heading.
My lord.
Compilation debate. I'm grateful, my lord.
I'm good.
Item number 10 to 29.
In 10 to 29, my lord, I am not pressing 10 and 11. 12 to
10 is your application.
all our application, all the applications are filed at our instance of Shoabajar Rajbari, my lord.
Okay. Now, item number 10, you are not pressing.
10 and 11, I am not pressing, my lord. My lord, 12 to 27 are connected with two properties of Shoabajar Rajbari, which
Let us take up 12, item number 12.
12 to 27 are connecting matters.
My lord, I am representing some of the Sebayers. It's a trust property, my lord. A copy of the applications, cost papers from 12 to 29 must be served upon us. We should be also very hard, my lord. These are the
On behalf of whom my learned friend is representing, he may submit. There are several Shebayats.
You have filed your vokalatnama for that.
until and unless I get the cost papers, I cannot file the cost. I cannot.
Why should I serve to all the Shebayats? This is the
I am
application.
representing some of the Sebayers.
You are representing whom?
I am representing, sir, please let me. I am representing the present, all the trustees, my lord. All the trustees, 4 trustees are there, and this is a suit for administration, and for the benefit of the deities, I'm filing this all the applications. There is nothing prejudiced with the Shebayas or the deities, my lord. My lord, may I kindly place just
No. What you see, these applications are to be heard. Necessary parties are to be brought on
Yes, I am a
record.
necessary party. I am a Sebayat.
my lord, kindly consider that.
No. What is it? Just give me a GA12.
My lord, if my lord,
Yes, my lord.
there was an earlier order wherein a division bench, whereas my lord was a part of the initial bench.
Let me see that order.
Property was sold without informing the Sebayas, and one of the trustees who were the party, who was a trustee, was not informed. Behind their back, my lord.
Just a minute. Let me see the application. Yes, you are appearing for
My lord, I am appearing for item number 25.
only item 25.
Only item number only item number 25, GA number 25 of 25. My lord, I am for my lord, in this matter, in the last date, my lord, direct me to file the power and vocalatnama in the department. I have already filed my vocalatnama in the department. And my lord, now I am my humble submission before your lordship that I am for the opposite party number 2 and 3. So kindly direct the petitioner to implement the name of the legal heirs of the deceased opposite party number 2 and 3, because the opposite party number 2 and 3 already died, and their legal heirs is to be implemented in the cause title.
May
I
I
direct
clarify?
the
Let
petitioner
me see GA12.
to substitute the name of the legal heirs of the opposite party
My
number 2 and
application
3
will suffice the
and implement the
intention
name of the petitioner number 2,
ওটা
respondent
দিয়ে দিন
number
না,
2
তাহলেই
and 3.
স্যার সাহেব বুঝে যাবেন।
I am for the item.
কোথায়?
I am for item number 25.
Only premises numbers are different, my lord. The contentions are same.
Because opposite party number 2 and 3 is already died, and that's why kindly implement the name of the legal heirs of the deceased of the opposite party number 2 and 3 into the picture.
My lord, GA 12 to 27, these applications are connected with 2 premises of Shobhabajar Rajbari.
GA12 to 27.
27, my lord. Some of the portions of these premises have been renumbered with other persons with the occupier in the name of the occupiers, my lord, with the record of the KMC. My only submission that let these recordings be renumbered in the name of the deities or the Devottor estate from the present occupiers. Whatever the names or the opposite parties we have found in the respective applications, my lords, are from the record of the KMC.
You are representing one of the trustees.
All the trustees, the board of trustees of the Shobhabajar Devottor estate, my lord.
You are representing the board of trustees.
What happened, my lord? These premises are belong to Devottor estate, and now it has become renumbered and renamed in the name of the occupiers. They have stopped to provide the rents, my lord. My lord, with may I submit one humble indulgence? Let the report be called for from the KMC. Under which document, on the basis of which document these applications were renumbered? Let the report become.
Yes, you are.
I am representing some of the Sebayas. 7 Sebayas.
The records are available from second quarter 77-78. I have obtained all the inspection books of the premises concerned.
Let it be served. I will come back. We will come back, my lord.
12 to 29.
Item number 12 to
12 to 27.
Sorry, 12 to
27.
I've been briefed in item number 12 to 27.
Just a minute. Just.
কি সইটা করেছে 2003 এর পাওয়ারটি জমা দিয়েছে 2003 এর কি সই করেছে পাওয়ারটা দেখে আমি এটাই হলো লিগাল
The availability of the records are prepared in this lordship and reports. All the IPs have been tried. For the GA numbers, I have indicated what all records are there.
Our only requirement on the basis of which documents the names were changed.
On which basis it has been recorded.
Yes.
From 1977 is, if I can hand over one of these records.
My lord, can it be possible to file through affidavit by the KMC? Because the in
Yes, sir. What is the report?
This is in respect of one of the IP. GA number 12 of 2025. This is in respect of GA number 12 of 25 and GA number 16 of 25. This contains B by 2 by H by 7.
So this is of 12 of 2025 and 16 of 2025. Yes,
There are
16.
numbers, Lordship. B by 2 by H by 7, Raja.
Yes, 16 of 2025 and GA
GA 12 and 16.
and 12.
Yes, 12 and 16.
So this is the inspection book.
Yes, inspection book with effect from first quarter 74-75.
So as per the municipality report, these are the records which are lying in the name of,
Provided, handed over to you, Lordship.
yes,
I have marked the GA numbers along with the premises numbers,
yes.
the inspection books available, and which from which period.
So as per the inspection book, this is lying in the, no, this is inspection book of which year? This is 2000? No, this is, you have been served with a copy of the petition probably.
yes, yes, my lord.
So it's better you collect the details and file a way of affidavit. Okay. That
Because
would be better.
one pertinent point, my lord, in all these applications, corporations has replied us. The reply is they don't have any document on the basis of which the names were. Let them file affidavit, my lord.
My lord, one thing, my lord.
Meantime,
My-
my lord,
my-
the applications we served. The
My
second-
lord,
Just a minute. Just
my
a
lord,
minute.
my lord, one
You are
thing.
representing?
My lord, just kindly go through the last order dated, my lord, 20 item number 26th August. In the last order,
Yes.
in this order, my lord, direct the opposite party number 2 and 3 to opposite party number 2 and 3 to file their power. I have already
You are,
disclosed.
okay, for regarding you, you are representing opposite party number
2 and 3. I have already disclosed the name of the legal heirs of the deceased of opposite party number 2 and 3 in my Vokalutnama. Kindly direct the petitioner to implement the name in the cause title in the record of the deceased legal heir of the deceased of the petitioner, deceased petitioner.
learned advocate.
That I cannot, my lord, because whatever I have the
learned
from the
advocate
records,
for
my
the
lord.
applicant, learned advocate for the opposite party number 2 and 3, and learned advocate representing Kolkata Municipal Corporation are present. Learned advocate representing Kolkata Municipal Corporation has filed a list of the information with regard to the property which is available from the records of the Kolkata Municipal Corporation. As the dispute is with regard to necessary correction and clarification by the municipal authority with regard to the records of the two premises being B by 2 by H by 7 Raja Nobokrishna Street, Ward number 9, Paraf 2, PS Shampukur, Kolkata 7,05,000, lying in the names of Sudhir Dotto as the premises number 2, Raja Nobokrishna Street, Ward number 27, Paraf 2, Police Station, Bottola, Kolkata, 7 lakh 5, in the name of the estate of Raja Sir Radhakanto Dev Bahadur, having office at 33 by R, Raja Nobokrishna Street, Kolkata, 7 lakh 5. This matter, yes,
B by 2 by H by 7.
yes.
Two IDs are there, two common IDs.
No, one is B by 2 by H by 7.
And one is B by 2 by H by 9. In the
Okay, and another is B by 2 by H by 9. Recorded in the name of B by 2 by H by 9, recorded in the name of
Atul Chandra Adhikari.
Atul Chandra Adhikari. This application can be decided upon granting opportunity to Kolkata Municipal Corporation to file affidavit giving necessary particulars.
My lord, affidavit may be served on upon
Yes.
all the applications.
Such, yes,
In respect of all the applications, 12 to
the
20
affidavit, a comprehensive affidavit may
Yes,
be
ma'am.
filed with regard to all the
it will be easier, my lord.
And my lord, one thing,
Such-
I am appearing only for,
Such affidavit must be served upon the applicant and the opposite party number 2 and 3.
2 and 3 in GA 25 or 25.
And in opposite party number 2 and 3 in GA 25.
GA 25 or 25, item number 25 of
GA
product
25 of 25.
25. Huh. And thereafter I shall file my
Now,
affidavit in opposition.
Yes,
I may be served. I am representing seven Sevais.
But I'm strongly object, my lord.
Okay,
My
one
lord,
of the-
he has not
yes,
filed the.
this
My lord.
learned advocate,
Mr. Ayan Kumar Boral.
Mr. Ayan Kumar Boral, submits that he is representing how many?
Sevais.
7 Shevites, which is disputed by the learned advocate for the applicant trustees. Learned advocate for the applicant trustees submits that there are many Shevites and it is difficult to serve all the Shevites. Stop. As the Shevites play an important role in the Devottor property, necessary copies must be served. However, it is necessary to ascertain as to total number of Shevites in the total number of Shevites, their name, and from the date they are discharging the duties of Sheviteship. Such position can be ascertained by appointment of a special officer. Thus, I appoint Dash as a special officer to ascertain as to the number of Shevites in the Devottor property of B by 2 by H by 7 Raja Nobokrishna Street and B by 2 by H by 9 of Raja Nobokrishna Street, Kolkata, 7 lakh 5. Such inquiry shall be conducted upon notice to the learned advocates for the trustees and other opposite parties. Upon completion of the inquiry, the report should be submitted on or before 10/11/2025. The affidavit of filed by the municipal authorities shall also be served in advance and be filed on or before 10/11/2025. Let this matter appear
My-
on 10/11/2025.
My lord,
And the copy may be served within 3 days or 5.
No, I am just directing an inquiry by the special officer as to the.
Passed an order to serve me. I am represent. I have the authority. I have been instructed to
My lord-
appear on behalf of 7 of the
Let him
Sevais.
file the Vakalatnama and serve me a copy.
I get a-
Then it will be clear.
I get the cause title. How can I file the
I'm
Vakalat?
just, that is why you see, yes, learned advocate, what is your name?
Mr. Ayan Kumar Boral.
Mr. Ayan Kumar Baral, who has claimed himself to be representing the
Sevais.
Shevites, will be entitled to appear before the learned special officer, and the inquiry should be held upon notice to him.
my lord, and I am for,
Until and unless what he
Baba,
is
See, first let it be ascertained. Thereafter, you will get every right.
and my lord, for item number 25, the legal heirs of the deceased person name will be impleted into cause title because I am already
in
filed the
In the
Vokalatama.
meantime, the learned advocate for the applicant is permitted to take steps to make necessary amendments by bringing records of the of the legal representatives of the deceased opposite
My lord,
parties.
opposite party should inform me because I have no idea who are the legal heirs.
I have already disclosed in the Vokalutnama.
When in the meeting to be held, you will get entire information.
And that's I shall intimate the legal heirs of the names of the legal heirs.
Yes,
And
yes,
very
yes.
well.
You will get a copy. You contest the
Now
matter.
already I have got the copy, my lord. I have already filed the Vokalutnama.
Legally, meet
Currently, and thereafter,
You made my notice. Okay. As to
who
who
are the legal heirs? And my lord, thereafter I shall file my affidavit in opposition.
My lord,
Yes, take back. Please take back.
Well, two other matters are
an
there.
appeal was carried out.
Just a minute. I am passing this order from 10 to enter.
No, 12 to 27.
This order holo from item number 12 to 27. একসাথে costed.
Which Lordship has noted.
Yes.
Premises number, this is only in respect of GA number 12 of 25 and GA number 16 of 25.
Very well.
In respect of every GA, there are separate premises.
Okay, you confine yourself with this much, and if you get the other information, incorporate in your affidavits. Whatever it is, entire thing you file a comprehensive affidavit in details. Regard item number 10 and 11.
10, 11, I'm
Okay,
not
learned advocate for the applicant submits that his client is not willing to proceed with this application. Let these applications GA 10 of 2024 and GA 11 of 2024 be dismissed as not pressed.
Well, 10 is not my application. I'm the opposite party. However,
No. How can you make it not pressed?
I'm not pressing today, my lord. It has been resolved. I will serve notice. It has been resolved. Dispute has been resolved.
Item number 10 and this order is confined to item number 12 to 25.
27.
Item number 12 to 27 of the একটা অর্ডারের মধ্যে সবগুলো করে দেবেন, ঠিক আছে? আর আইটেম নাম্বার 10 and 11 একটা অর্ডার করে নিন। Let this appear on 10, 11, 2025. ঠিক আছে? 10 and 11 এ ওই অর্ডার করে দেবেন, let this matter appear on 10, 11, 2025. না। Let this matter appear on 10, 11, 2025. দুটো ম্যাটারই তাই করে দেবেন।
Will my lord take up 28 and 29?
28 is for?
28 and 29 are prayer for development of two Devottor properties.
These application may be served.
Okay, then I shall do one thing. Let this matter, item 28 and 29 করে দিন তো। Let this matter appear on 10, 11, 2025.
And my lord, these two applications may be served. If my lord recollects, one of the trustees who was appointed by this court was never intimated two properties were sold. Justice an application was filed by the trustee whom I had represented, ex-trustee Dilip Narayan Dev, had challenged the sale and for removal of the board. Justice Pattanayak had removed the board, receiver was appointed, thereafter election was held. My lord, in the meantime, an appeal was carried out by my client, wherein my lord was a part of the division bench, wherein my lord's view was that since the territorial jurisdiction of the property was within the Barasat, it has to be filed within Barakpur, my lord. These two applications may be served upon me.
What is the relevancy of the facts in these applications? This is a prayer for development.
A fraud was preyed upon. A trustee, not a Sebayat, a trustee.
Okay, you appear on the next day. I shall see.
My lord. These applications may be served, my lord.
Why, my lord?
What
him
would happen,
filed up.
They would sell the property. They enter into a
No, without leave of the court, they cannot
Yes,
sell the property.
That is why I have come before the lordship.
better offer.
Yes.
If we have a better offer, we can place it until and unless.
You see, so many outsiders, purchasers are being permitted to intervene. So definitely will be permitted to intervene on the next day. If you can show some cause.
Published.
So let it appear on 10, 11, 2025,
My lord.
28 and 29.
And my lord, in the meantime, I shall give the name of the legal heirs of the deceased to them, and and thereafter I shall file my affidavit in opposition for GA 25 of 25.
Yes.
Grateful, my lord.
Item number 30.
Notice be also be served upon me to hold the meeting by the special officer.
No, I have given that order. You incorporate your name.
I have given my name.
Yes.
Your lordship.
In item 30, my lord, I am for the plaintiff. Lord, we have been able to ascertain the legal heirs of the defendant who is since deceased and the subsequent purchaser of the relevant property. So I need to, yes, my lord, I need to take steps, my lord, to bring them on record. Lord, kindly keep it.
Whose application is this?
It was our application. I'm being led by Mr. Shaunak Gupta.
Okay, you are,
My lord, this application we should have filed for substitution and bringing certain other subsequent purchasers of the property before your lordship. Because the defendant number 1 has sold certain parts of the property which was the subject matter of the partition suit. And my lord, since then he is deceased.
so you take steps to ascertain the
Steps. Yes, my lord. I'll file an application.
yes, record and order. Learned advocate for the applicant is present and prays for time to take necessary steps as to the name of the purchasers to whom the deceased defendant sold the property. Thus, such the time is granted. Let this matter appear on 3/11/2025.
Grateful.
Item number 31.
May it please your lordship, my lord, this is my petition. My lord, today I'll be troubling your lordship because I'll be, my lord, praying for an order of stay. My lord, essentially an order of status quo being maintained in the matter.
What is this? Oh, yes.
I'll quickly indicate this is a petition under section 263 of the Indian Succession Act, my lord, for revocation and annulment of a probate granted in the year 2011. Lord, before I start, may I quickly indicate this is a property, my lord, which is
No, this application you have taken out for
for, my lord, annulling an order of probate granted on 1st of October 2011.
2011.
I'll indicate very interesting facts, and this has to be gone into by your lordship.
This has to be hard on contest. You are
Indeed, my lord.
representing?
I'm representing both the respondents.
I'll indicate who the respondents are.
Respondent,
All that I
executor.
need,
My
my
lord,
lord, before my learned friend
Yes.
starts, my lord, because it's my petition, I'll have to indicate a few facts.
No.
my lord, affidavits are
You
complete.
see, whatever it is, affidavits are complete.
Affidavits are complete, but
So it has
today,
to be hard on contest.
Yes.
but till then, kindly hear it on contest on any day. But till then, my lord, kindly grant us an order of status quo. I'll indicate why.
When did you file this application?
This application, we have come to learn of the entire proceeding in the end of 2024. My lord, kindly take up paragraph 26 at page 18.
Yes.
My lord, the applicants first came to learn of the grant of probate on 6th of September 2025, and I'll indicate why. Lord, the gentleman passed away. He is, my lord, the grandfather of the present, my lord, petitioners. My lord, he passed away in the year 1969. 42 years later, my learned friend's mother, so my lord, the respondent number 1's mother, who is, my lord, who has passed away, she applied for, my lord, probate. That's 2011. Now, these facts are very important. 42 years later,
It was a non-contentious.
that's what they contend, because I'll indicate why. My lord,
Affidavit
this-
of consent.
this practice of Mr.
consent.
Borzon, I don't understand.
Let me
He-
proceed with the matter, okay? And because affidavits are
Lord,
exchanged.
kindly grant me a stay till then. Whenever, my lord, your lordship is, that's the problem. And when it has been sold, now, my learned friend should
There
have,
was an
the
interim order by
moment,
passed by
the
High Court
moment,
that was vacated. Subsequent, they do the
that
property.
may I only submit this. He will have his chance, but he should know that the petitioner gets a chance first. So it's my petition. Yes, so I have to make that submission.
After
My learned friend has forgotten the basics. I'm sorry. But kindly take up. I'll indicate why my learned friend's client. I'm not telling it to my learned friend at all. It's my learned friend's client. But kindly see what fraud they have played. We had an order of injunction. But the moment we come to know of this, we approach the trial court. But we get an order of injunction, ad interim order of injunction. They filed an order 39 rule 4. Kindly take up that petition, and I'll indicate why I'm making this prayer. Kindly take up that petition of order 39 rule 4, where
Which page?
this is starting from page 54, my lord. Page 54. That's the petition that they have filed under order 39 rule 4. My lord, there is no whisper in this entire petition that the property has been sold. No, please. Kindly allow me to kindly allow me. Now that is the prayer. That is why they should not have made this submission. I'll indicate why. My lord, Order 39 Rule 4 petition, kindly have a cursory glance, no whisper that the property is being sold. Now, my lord, it's a lis pendens case, I'll indicate. With this, my lord, kindly see the order that has been passed by the learned trial court, which is, my lord, at page 83 onwards, the operative portion, your lordship will find the date, it's page 67. Page 67, and the operative portion, my lord, is at page 69. Your lordship will kindly take up page 69. That one paragraph is the reason given by the learned trial court.
Just a minute. This page 67.
When we had an interim order, ad interim order in our favor, we will kindly see page 69. I've carefully gone through the case record, the applications of the plaintiff, the application of defendant number 1, and photocopies of documents annexed by the parties to the suit in support of their application, wherefrom it is prima facie established that Nita Dash, I pause here, my lord, Nita Dash is the mother of respondent number 1. Respondent number 2 is the husband of respondent number 1. Was the daughter of
Page 67 of the order of the
69, my lord.
page 69.
67 it starts. The operative portion is one paragraph at page 69.
Yes.
I have carefully gone through the case records, the applications of the plaintiff, application of defendant number 1, photocopies of documents annexed by the parties to the suit in support of their application, wherefrom it is prima facie established that Nita Das was the daughter of Joel Chinnaswamy David, as revealed from the last testament. I pause here. Last testament is the will that the court is referring to, which is under challenge before your lordship, which has been marked by defendant number 1 as annexure C, but the plaintiff suppressed this material fact. We never knew about this. This is what is under challenge in the present proceeding, which we came to learn from the Order 39 Rule 4. That's our case. And on the basis of that, they say it's suppression and this is vacated. Now, problem is, my lord, the moment this is vacated, my learned friends very, very conveniently sell off the property. It's lis pendens because they say now there is no interim order. So let us go ahead and do what we want. They sell off the property. That shows their conduct. All I'm praying for is, my lord, let that status quo be maintained till the time, my lord, that the matter that is heard. No further steps. Because no, that CL deed is not executed yet. There's nothing on record. So, my lord, today, even if it is executed, even if it is executed, my lord, my interim applications are all pending.
Kindly see the opposition.
Let me see the affidavit in opposition.
Kindly
see the affidavit in opposition, my lord.
My lord, kindly see.
There is no whisper in the Order 39 Rule 4. So if they wanted, my lord, this is all a ploy to defraud, my lord, the petitioners.
My lord, page 17. Kindly see, my lord.
Kindly take up page 17, my lord.
Property has been sold.
It is immaterial. Even if it is sold, it's lis pendens. So the matter is pending adjudication before the court.
The protection the doctrine of lis pendens affords him.
Of course, my lord, I'll argue. But till the time I argue, my lord.
No, this is executed 5th day of May 2025. Oh, when did you file this application?
Lord, my petition in, my lord, the trial court was pending then. That's when the order was, my lord,
This GA application.
Well, subject to correction was filed on 9th of July.
9th of July.
That's when the trial court proceedings were still pending. It's still pending as on date.
Get this, my lord. The trial.
The 9th of July, that's, my lord, page 20. I do not understand, my learned friend. Why is he so scared that he will not get a chance? Of course he'll get a chance.
It's a question of propriety.
So you wait for your propriety, you wait for your submission, please. That's not what we follow. Page 21, my lord. 9th of July 2025.
Yes. So that is, I think it is sold by one of the opposite parties.
One of them, my lord.
One of the opposite parties to,
my lord, who is not
to a third party.
To a third party, my lord, and that we have also indicated. Your lordship will kindly take up our, my lord, pleadings in our petition, where we have stated that where the cause of action arose. My lord, kindly take up page 6 of my petition. Kindly take up paragraph 6. This is where it all started. They knew very well that this is what we are going to do. My lord, kindly take up page 6.
Yes.
Paragraph 6.
Paragraph 6. Yes.
On 3rd of May 2024, the applicants were shocked to receive a letter from respondent number 1 purporting sale of half of the undivided share of the said premises to the applicants for a consideration of 2.25 crore within 7 days from the date of receipt of the letter, failing which respondent number 1 would sell the property to one Shri Varya Estates LLP. That's a developer. And the only reason, my lord, is my learned friend's mother was not related to this family at all. They claim she was the daughter of, my lord, the grandfather of the petitioners.
Different issue whether the probate was granted in accordance with law, not
52
whether.
years later. Yes, my lord, that has to
Yeah,
be
but
gone
it-
into by
that's
the
a
honorable
different-
court.
That's a different.
My lord, my lord.
But the question is, so far you are playing for an interim order
Of status quo being maintained, Lord, nothing forward,
with regard to what?
Lord, with regard to the property. Because we are in possession of the property, my lord, from the last 70, 80 years.
Which property? That is.
This is, my lord, the property which is in issue, which is, my lord, kindly take up page 4, C,
Page 4.
premises number 28, Elgin Road. My lord, it's a huge property just opposite of, my lord, Shambhunath
This
Pandit
property
Hospital.
is not yet sold.
No, my lord. They
Half
contend it is sold.
Which page? That is
Well,
why.
kindly see the
That's what
opposition.
they contend. Page 17 of the opposition is what they're contending. We are, my lord, challenging that entire process
Lord,
because
may I
not one
indicate
side.
this?
No, you please kindly grant me this opportunity.
You see, now we are confining ourselves to this interim order.
Lord,
My
kindly
lord.
see
Now the
page
With the interim order, my lord, I'll indicate.
Question
My
is
lord.
regarding your paragraph, that is your position in the property is in which property? Let us see.
Same property. My lord. This is the property where, my lord, we are residing.
Oh,
Your lordship will kindly take paragraph 2.
okay, paragraph 6 is this letter, okay? Paragraph 6.
But paragraph 2 is, my lord, where we state,
Paragraph 2 is
my
where
lord,
you
the
state-
details of the property. All are residing at the 5th line in paragraph 2.
Paragraph 2, yes.
It's being filed by, my lord, Neil David, who is the son. So it's the grandfather's property, my lord. The grandsons and granddaughter, they are staying there. That's what is pleaded.
So this is
And
your-
what my learned friend's contention is that the.
So how have you dealt with this paragraph?
My lord,
Paragraph-
I'll indicate. My lord, kindly take up the affidavit in opposition.
Once my lord poses questions to me, let me answer them.
I'll
just
first.
a
My lord,
minute, just a minute. First of all, let us ascertain the position, okay?
that's paragraph 5 of the affidavit in opposition. My lord.
5 we have
My
dealt
lord.
with.
Paragraph 5 of the affidavit in opposition. Mere denial.
What more?
What more is for you to answer?
Certainly
My lord,
not.
kindly see paragraph 5.
Certainly not. My lord, kindly indicates. My lord, kindly
I'm sure my learned friend will wait for his opportunity. He can shoot his guns, but I'm sure
There
he'll
was a
keep
question
them
posed
loaded.
from the bench.
My lord, kindly take up paragraph 5, my lord. I understand the excitement of Mr. Berthun for obvious reasons, but he's under instructions. But paragraph 5 is what, my lord, I'm indicating very humbly. Kindly see how they have dealt with this. This is without any opposition, my lord, in common form, not in specific form. Solemn form and common form are the two forms which were to be gone into. my
Going
lord.
into all those things,
Lordship.
let us prima facie be satisfied. What is the present position of
My
the
lord, we are in
people?
possession. They can't deny that. They also know, my lord, we are in possession. So if we are in possession, they'll be thrown out without this matter being decided, the issue being decided.
Seize this, my lord.
But this is unheard of, and I'm sure, my lord, the difficulties now. The order 39 rule 4 has been held. We are in process of filing an appeal today, my lord. At
But
this
when
stage,
was
there is
order
no
passed?
order. So, my lord, they immediately showed the colors by selling off this property. They contend we have sold it off when the trial, my lord, the matter is pending before the trial court. Can you see the next page, my lord, page 3? All that they say is it's wrongly and illegally claimed to be the owner of undivided 1/2 share in premises this. So they are also contending it's an undivided 1/2 share. So as it is, the position has to be maintained because today, my lord, if it's an undivided property, unless and until there's, if I take his case to be correct to the hilt, then in that situation also, the status quo cannot be changed. I can't be thrown off of the property because it's an undivided share. That's their statement. Their statement is it's an undivided 1/2 share. If that's the case, my lord, then with that undivided 1/2 share, I'm sure my learned friend will not contend otherwise, that the developer can come and throw us out and not develop the property. For that, there are steps in the matter which are to be taken. Before that, I'm sure that this matter will be decided by the Honorable Court.
Let me see the paragraph 5.
With this, my lord, I'll urge your lordship to take up paragraph 3 of the affidavit in reply as well. You have to
Paragraph page 17 is with regard to this page 17 of the affidavit in opposition. That is with regard to
Sale, my lord,
sale
of the undivided half share property, my lord.
undivided half share.
That is at page para 17 at page 12 of the affidavit in opposition, my lord.
Page 12, my
Undivided
lord.
share means you see, you have sold the share.
My lord,
That
may I
means-
indicate? My lord, let me indicate.
Yes, now what is the contents?
My lord,
Have you handed, no, as per the sale deed, is it stated that possession is handed over?
Position is with us. That's the undivided.
may I
My lord,
indicate, my lord? May I indicate?
Yes, yes.
position is still with us.
My lord, may I indicate? what exactly transpired, my lord?
No, the question which has fallen from the honorable bench is whether you are in possession. We are in possession.
My lord, may I indicate what
No,
exactly
this is half, no, possession is entire
Entire property we are in possession.
request property. Half portion is according to your learned friend. So far, this document is
Undivided. So, my lord, they can't really act upon it.
divided half
It's an
share.
undivided property, my lord. If my learned friend's contention,
So you see, half of the share is transferred by selling.
Divided half shares transferred. Now, my lord,
Yes.
what exactly transpired, my lord?
Yes, yes.
Initially, my lord, since we claim, and it's, my lord, it's a fact that since Nita had the undivided one-half ownership of the property, her daughter sought to sell. She gave a notice to the other co-sharers saying that, look here, I want to sell. This is the price I'm getting. If you want to purchase my share, kindly purchase it. Now, my lord, after receiving the letter, they don't reply. They go to the court, file a suit for declaration injunction with the idea that Nita Das, meaning thereby, my lord, the mother of this, of the, my lord, the respondent number 1, was nowhere connected to the property, or was not the daughter of Joel Chinnaswamy David, who was the initial owner.
Now the question is, you see, the fact, let us see, so far the grant of probate is concerned, probate was granted in favor of.
Kindly,
No, let us go by one by one.
Hears me out.
Yes.
Comes later. Kindly hears me out. So, Mullah, they have an order of injunction, ad interim order of injunction.
Yes.
We receive notice.
What is the reason?
No, kindly. We received notice. We filed 39 Rule 4. That was allowed sometime in the month of November 2024. No appeal preferred therefrom. So, Mullah, my learned friend's client has accepted that order. This was in November 2024. After the interim order was vacated, Mullah, I sell the property. The property was sold in the month of May. We waited for 6 months to see whether an appeal is forthcoming or not. Nothing happened, Mullah. We sold.
You sold the property in the month of July.
May.
Yes, month of May. This application was filed in the month of
July. Thereafter, Mullah, kindly visualizes. In the month of November 2024, the interim order is vacated. So, Mullah, they come to know the case of the respondent in as late as as early as in 2024 November, Mullah. So they know a case. Interim order gets vacated. I sell the property in May 2025. They wait for 7 months. Then they file this application.
2025 mean the month of May you sold.
Yes, they filed this application.
July 2025.
After the sale.
After the sale, that is 2 months after.
Yes, Mullah.
They
Now,
filed this
the
application.
issue is very simple, Mullah. Issue is, Mullah, had they been aggrieved with the order of November passed by the learned trial court, where, Mullah, the interim order was vacated, they could have preferred an appeal. 6 months we waited to see whether an appeal was being preferred or not. Till today, no appeal. So that order, Mullah, stares at my learned friend's client.
Once my learned friend has submitted, I'll make a few submissions.
No way.
In reply, quickly, my lord, I'll go by another, my lord. Kindly take up my prayer E at page 19 of the petition. That's all that I'm praying for, and I'll indicate how, my lord.
Question of
Today,
an interim order doesn't arise, my lord. It has to be heard out, I admit.
Once my learned friend has
Affidavits have been
made his
exchanged.
submissions, I'll make submissions.
But question of interim order does not arise, my lord. Kindly cease.
My lord, if my learned friend is
The conduct, my lord, interim orders, my lord, also premised on the conduct, my lord.
I'll
If
indicate the
person,
conduct, my
if
lord. I'll
the
indicate the
person
conduct.
waits from November 2024 till July.
See, before passing an interim order, the court is scrutinizing the facts, whether there is any further scope to pass an interim order. Thereafter, the question of discretion.
I bow down.
If there is a scope to pass interim order, court can use the discretion either to pass or not to pass.
I bow down. I say, my lord, kindly visualizes that ad interim order of injunction which a learned friend's client enjoyed, restraining the sale of the property was vacated in November 2024. If they were aggrieved by the order, my lord, they could have filed an appeal within the time frame, my lord. They do not file an appeal. So that order as of today has attained finality. Then, my lord, I wait for 6 months to see whether an appeal has been filed or not. Property has been sold in May 2025. Now, my lord, in July 2025, this application comes
Anyway,
with an interim.
now let him submit.
Quickly, my lord,
I've
I'll
got your
encapsulate
clarification. Now let him submit.
what he has submitted, my lord. Today, the admitted fact is, my lord, from paragraph 5 of the affidavit in opposition, paragraph 2 of the petition, my lord, dealt with in paragraph 5 of the opposition, which is dealt with paragraph 3 in the reply. The fact is, my lord, that they have not denied that we are in possession. Number one. If we are in possession, my lord, even till date, my learned friend's contention is a sale has happened in the month of May. My lord, that's the contention of an undivided share, 1/2 share. My lord, undivided 1/2 share, we cannot be thrown out unless and until, my lord, it is crystallized which half of it. I'm not even going by, my lord, what we have stated, what contentions are there. Today, all that I'm praying for is prayer E at page 19, because we do not have an order by which we will not be dispossessed till this, my lord, this is decided. All that I'm praying for is we have stayed there all throughout. My lord, 42 years later, they try and get a will probated from 69 to 2011. My lord, today, all that I'm praying is a status quo in the nature that, my lord, will not be thrown out of the property till this is decided, which I beseech your lordship to pass in our favor, my lord, because today my contention is, when we have come to know in September 25 of all the details of the matter, lord, we have contended that the respondent number one's mother was not related to the family at all, which they are claiming that she was the daughter of the grandfather, my lord, of our grandfather. My lord, that's not factually correct. We'll show that. For that, my lord, the matter has to be gone into. There was no, my lord, solemn form, no citation. It was in common form without any opposition. They've got an order, absolute collusive action. I'll indicate that. But in the meantime, there is no dispute to the fact, my lord, in the affidavit that we are in possession. If we are in possession, it's an undivided share. If I'm going by what Mr. Bordon is contending, that sale has happened and sale is for undivided 1/2 share. I'm going by his contention. If that is the case, my lord, I can't be thrown out unless, my lord, it is crystallized which part of the property actually belongs to them. In that case, till then, Lord, I'm only praying for an order that we should not be thrown out of the property. That's all. So, my lord, my learned friend has made his submission. I have conceded to his facts as on date, and with his facts, I'm making this submission.
Paragraph 6, probably you have dealt with this thing. Paragraph
Paragraph
6.
5 and
No,
6.
no, paragraph 6 of your affidavit in opposition, probably. You have dealt with that.
Yes, he dealt it. And will kindly visualize this. If this is the prayer, my
lord, even in paragraph 6, it has not been
kindly,
stated that they, even in paragraph 6, it has not been stated that they are not in position. We're not in position.
Should not be thrown out of the position.
All that I'm praying for. All that I'm praying for.
A civil suit is pending, my lord.
That's why it's pending.
Civil spending. What would have otherwise been the proper course of action, my lord? The proper course of action would be go there before the civil court, seek amendment of the plaint, challenge this deed, and there seek an order of injunction.
I'm very grateful to my learned friend for that advice. We'll do so, my lord. But
so, my lord, he could do this in that court.
No, we can still do.
Fine. Then that court has to decide whether in the facts and circumstance of the case an injunction is warranted or not, my lord. Certainly not before this court.
Of course, before this.
Because, my lord, the initial order of restraint was passed by the civil court, vacated by the civil court. 7 months thereafter, they did not prefer an appeal. In the meantime, they sold the property. Number one, my lord, my learned friend client should be happy with whatever protection the doctrine of dispendence affords him. Number one. Number two.
That's all that I'm praying for here before this honorable.
No, most importantly. So that is not to be claimed. Dispendence is a matter of course, my lord. That part, my lord, he has to go before that court and say these are subsequent events. Property has been sold. Now I challenge that deed.
No, regarding that, regarding that probate, the court, it was before the court, okay?
Yes.
At that point of time, this application for revoking that grant of probate was not pending before this.
I appreciate, I bow down. Kindly visualize this.
Yes.
When this order was being passed in the month of November, this application under Order and Rule 4 was filed prior thereto, was filed prior thereto. So they could have then and there taken on an application before this honorable court for revocation, gone there and said, we have already applied for revoking the grant. They could have done that. They have not, my lord. They had allowed, my lord, the Order and Rule 4 to be disposed of. Disposed of, vacating the interim order.
That's not factually correct. My paragraph 26 says that.
My lord, kindly. So, my lord, they had allowed the Order and Rule 4 to be heard out, interim order to be vacated. Then they wait for 7 months, my lord, from November till July, my lord, roughly 8 months to file this application. Well, had they been peeved with that order, my lord, the normal recourse would have been to take out an appeal immediately, challenging that order, because they are aware of the stance taken by my client, my lord. They were aware of the stance. So, my lord, would your lordships permit?
So the suit was filed by
them,
Mr. Bach's client, for declaration and injunction.
Yes.
The moment we came to know, my lord, that what they are, kindly see paragraph paragraph
That is,
my
no,
lord,
no,
9.
page 65, I think.
My lord, it's
Page-
also my lord,
Page 65, I think,
But
was.
suit,
yes, my lord, the plaint is starting from
Page
page
31.
30. Page 30. my lord.
Right, right. The order of injunction passed on,
So the order of injunction was in our favor, my lord,
that is
17th May 2024, my lord.
17th of May 2000.
2024, my lord.
The order-
Status quo was granted in our favor, my lord.
No, anyway, it is not here in your
Lord,
petition.
The petition, my lord, it's page 43 is where, my lord, page 43 is the order 39 rule 1 and 2,
Page 43.
my lord.
But the interim order, my lord, is
Okay, this
dated
is
8
your application
It's our application, my lord.
for declaration and injunction.
That's our application, my lord.
So you, in your suit for declaration and injunction,
Injunction was granted in our favor,
no,
and then,
that
my
is
lord,
with regard to the property which
status quo.
status quo.
Status quo with regard to the
that
property.
was vacated, and
That
after
was vacated, and after being vacated, my lord, we filed a petition here before this honorable court. In the meantime,
question is, after the interim order was vacated,
my lord,
within a period of 1 year, this sale took place.
that's
7
because
months.
it did, my lord, because I'll indicate
2000, I think 2024, the interim order was
24 November, my lord, 24th of
Okay,
November
my lord,
2024, it was
sale
vacated.
on 5th of May.
Before that, my lord, 5th of May, they did something.
Okay,
That's
6/9/2024.
24, my lord. Then kindly take up paragraph 6 of our petition.
11/11/2024, it was vacated.
My lord, kindly
It was
takes up
vacated,
page
my lord.
64.
Then kindly take up
4 years.
page 6.
64, my lord, then my lord, kindly takes up page 65.
Page 65.
The first letter is at page 29, which my learned friend should indicate. Page 29 is the first
It has come
letter,
by the court order, okay?
my lord.
When they took steps.
My lord,
6/9
6th of September, we file order 39 rule 4. That would be, my lord, apparent at page 64.
Okay, 64, you took out that application to vacate that interim order because it was an ex parte ad interim order.
The ad interim, and
Okay.
we said this was
Now on
obtained by
the
suppressing.
okay, on the basis of the relevant documents, the order was vacated. Okay, what I'm going by, what is the order
Yes,
of the
yes,
court?
I bow down.
And thereafter, how much time did you wait from 6
3rd May
My lord,
2024.
we waited for 6 months.
Okay, 6/9/2024. And when did you sell this property?
5th of May.
I'll indicate why 5th of May, my lord. Kindly take up page 6 once of the petition.
Page 6.
Of the petition, my lord, my cause of action to approach this honorable court arose in what we have stated in paragraph 6. They are not the co-sharers. They have no right to give us a
My lord,
notice
kindly
that you buy
visualize.
out the balance of the
My lord,
property.
in that
Kindly
event-
take up
Okay, now paragraph 6 is this.
paragraph 6 of our petition, 3rd of May. We were shocked to notice that they have given us this letter. That's what, my lord, prompted our action to approach this honorable court.
No, this 2024. Kindly seize.
My lord, kindly sees what happens thereafter. Once, my lord, paragraph, kindly take a paragraph, my lord, 26. This is very important, my lord. Certified copy of the probate proceedings, which we received on 20th of December 2024. That's page 70.
Question is, after the interim order was vacated, okay, that is the injunction.
My lord.
6/9/2024.
My lord,
Lordship.
6/9/24, my lord, I filed order 39 rule 4.
Yes,
Now
yes.
that was disposed in the month of November.
That was disposed anyway, 6/9/2024.
So, my lord, on
It was
6/9/24,
Okay, and
they are aware of my client stance.
now the question is, after receiving your letter dated May 3, 2024, they filed a suit.
No.
File the entire.
My lord,
Let him
kindly-
submit.
no, it's not this way, but kindly seize.
Let him first submit. I'll clarify there.
Initially, my lord, I sought to sell my undivided half share.
Yes,
I gave them a notice.
that is why May 3, 2024, you gave them
My
a
lord.
notice.
2024.
Yes, yes.
I sold the property in 2025.
In the meantime, what happened? Okay.
After I gave
May
them
3,
a notice.
2024.
We
you gave
filed a
them
suit
notice.
immediately thereafter, my lord.
Okay, after receiving the notice.
Notice, we immediately filed a suit.
Okay, very well.
In order of injunction.
Yes.
We, on 6th of September, we filed order 39 rule 4. That was disposed in the month of November.
In fact, I'll tell the date. 16th of May 2024 is when we filed the suit, my lord.
Fine. 16th of May 2024, they filed a suit.
Anyway, after receiving this.
Immediately.
Yes,
Immediately.
absolutely. Then, my lord, they get an interim order on the 17th. My lord, I file an application for vacating the interim order 39 rule 4 in the month of September, 6th of September.
Yes, yes, yes.
So 6th of September 2024, my learned clients are aware of my stance. Then, my lord, the interim order gets vacated in the month of November.
Still no, my lord, dealing with the possession.
Okay, just a minute. So, so letter issued by respondent number 1.
Yes, my lord. wanting to sell the property.
Is it page 20, my lord, of the
It is
petition?
page 6.
29. Page
Page 6.
29, my lord.
Okay.
Page 6 is the
respondent
pleading
number-
and the document
respondent
is the
number
page
1 issued
29.
the letter upon received you on May 16, 2000.
On May 16, you filed the suit, my lord.
Yes, May 16, you filed a suit, obtained the ad interim order.
Ad interim order, my lord, on 17, the next day, my lord. Status quo to be maintained with respect to the nature, character, and position of the suit property.
Okay, ad interim order.
I, on 6th of September, file order 39 rule 4.
Okay, 6th of September.
September
you filed-
2024, I file order 39 rule 4.
And from those documents, my lord, we come to know a lot of facts.
Yes. So on 6th of September
Or-
2024, they come to know about a lot of facts.
No,
On
order
6th September.
39, you filed and enclosing the annexing
Yes,
relevant
yes. So they
documents.
come to so they
So
come to know
order
about the
39, rule 4 was
was
filed.
disposed was filed on 6th of September.
Yes.
13th
That was
November.
disposed of on 13th of November 2024.
Same stand.
So, 13th November 2024, interim order vacated.
Yes.
Now, my lord, no appeal forthcoming.
Yes, yes.
I wait for 7 months before I sell my undivided half share on 5th of May 2025.
5th of May.
Yes, 2025. That's at page 17. Now, the record reveals that this application for revocation was filed in the month of July of 2025 after the sale.
1 year after the order, after knowing my stand.
Now, the most important thing, on 6th of September 2024, when I file my application under Order and Rule 4, my stance is made clear to my learned friend's clients. And his clients get to know a lot of things on 6th of September 2024.
Page 56.
He's admitted.
Yes.
So, on 6th of September 2024, on their coming to know about a lot of things, they wait till July of the next year to file an application for revocation. This is the conduct, my lord.
And I've given the probate number.
So regarding sale of undivided share, did you intimate by notice that it is sold or something?
No, my lord,
regarding-
they have never.
Why?
Never. Not even till date.
No.
When the matter was pending before the tribunal.
Never.
That was, may indicate, Mr. Bag is not there, my lord. I appear in the court below, my lord. We had filed an affidavit annexing the copy of the, my lord, the sale deed.
Postal.
Even after that, my lord, no application for amendment has been taken out in the court below. No application for injunction, my lord, in the nature has been sought for hearing, my lord, has been taken out. The proper procedure would have been, my lord, go there, file an application for amendment, and, my lord, seek an order of injunction of status quo or
Anyway, these are the admitted facts. Okay.
admitted facts.
Now,
One more admitted fact, my lord, which my learned friends
Yes.
should point out.
They are in possession of the entire
We are in possession of the entire property.
property.
And we've always been in possession.
No, admitted.
That's all.
But
That's all. If they have admitted this,
Kindly no.
and if they have admitted
I
it's an
have to.
undivided share,
Lord, I
one
cannot-
half which is
I
sold,
cannot,
then
I
my
will not.
my prayer is, my lord,
My lord, I
a very
cannot-
justified
my lord,
prayer.
may I put it this way. I cannot and I will not shy from facts. But the point, my lord, my learned friend might have a cause, but it doesn't have a cause of action, my lord, to approach this court with this relief, my lord. He might have a cause, very well. He does not cause of action, my lord, to approach this court for this relief.
now you are
I don't know why
admitting
the
that
excitement.
the share is sold, but your Mr. Bag's client is in possession.
Yes. Now, my lord, at any order, my lord, this possession has to be passed by the trial court. Kindly visualize this, my lord. If today he's aggrieved by the sale, then he has challenged the sale. Without challenging the sale, my lord, he cannot have any order. That's the primary relief. Now, which court can grant it, my lord? Subject to correction, my lord, is the trial court which can grant him this order, this relief. So, my lord, the proper procedure would have been, my lord, go there, file an application for amendment, saying that subsequently this has happened, property sold, I challenge the deed. And then seek an order, my lord. Without amending the plain, my lord, he cannot seek an order out there. Thereafter, my lord, it is open to the learned court, my lord, to decide whether in the facts and circumstances of the case, an injunction is warranted or not. But certainly not this court.
Where is this prayer for stay of a person?
And,
Where is the
and my lord, most importantly, my learned friend points out, my lord, there's no prayer that Mr. Bag is now making at the bar in the petition.
Yes, no prayer.
prayer for stay of sale? কোথায় চেয়েছে?
Kindly seize, my lord, kindly seize.
Kindly see prayer E What my learned friend is, my lord, indicating. It's in the nature of the prayer that I am making. Also, my lord, prayer B, prayer E.
Notice of motion.
Kindly see page 20.
Notice of motion.
This is as if the sale has not taken place.
Also, ad interim orders. Of course, my lord, the honorable
is-
court. All that I've prayed
Mold-
for
my lord,
is, my lord,
may I say this,
so that
my lord?
there may not be
Molding of
multifarious.
In my most restful submission, my lord, molding of reliefs is not possible at the ad interim stage or the interim stage, my lord. It's only at
Molding of relief, my lord. I'll indicate once my learned friend has submitted. Kindly see.
I will. Kindly see prayer E.
He said B, so B
The B with regard to revocation. CCE, fine. A perpetual injunction, may I place it?
Yes.
A perpetual order of injunction do issue, restrain the respondents, each of them by themselves or by the agents, assigns or otherwise, whosoever from dealing, disposing, alienating, encumbering, transfer, changing nature, character, creating third-party rights in respect of properties. Does this take into account an incident post-sale? Has my learned friend pleaded that there's been already a concluded sale? It's not there, my lord. So prayers with regard to relief,
Because, my lord, I'll indicate once my learned friend is done, my lord, I'll answer to all the
absolutely.
points that he's seeking to arise.
My lord, kindly see.
To raise.
So in the prayer, my lord, there's no relief sought. On the same lines as what Mr. Bagh is now, my lord, praying for at the bar. So, my lord, the next issue is, if my lord could then mold the relief. No. My learned friend says not required. But nevertheless, when I say this, molding of reliefs at the interim stage is not permitted, my lord.
That's not my prayer, my lord. I'll indicate.
Fine. Even then, my lord. So if my learned friend confines himself to the prayers, my lord, the prayer made by Mr. Bagh at the bar cannot be granted, my lord. Kindly cease.
And he could have indicated in the beginning that he did not have these prayers.
Kindly cease, my lord, prayer E. Now, does this indicate status quo as regards possession? Because good buddy, my lord, knows this very well, my lord. A co-sharer not in possession is deemed to be in possession through his co-sharers. That's the settled law, my lord. A co-sharer of property, my lord, is deemed to be in possession through his other co-sharers. That's why, my lord, he can file a suit for partition.
That's my case. You are not a co-sharer. That's all the case.
That's the reason I say. His case is, I'm not a co-sharer. This stance was disclosed in the authorized rule for application in the month of September. Lord, he merely waits for 10 months to file an application for revocation of grant of probate.
And suppress the
And Lord, most importantly, an order of vacating the interim order on in the month of November, he doesn't file an appeal against that till today. In these facts, my lord, is my learned friend entitled to any interim order?
When affidavits are complete, my lord, should be.
And affidavits are complete, my lord.
If my learned friend has submitted, my lord, I'll take 2 minutes and I'll conclude my submissions. 2 minutes. Can you take a prayer? I'm sure my learned friend will not rejoin to this. If he has anything to say, my lord, let him complete. Once he's done, I'll take 2 minutes of your lordship's time. Anything, Dada? Sure. Very briefly, my lord. No, I do not know. You can make your submissions.
If you confine it to it, then I transfer.
I urge my learned friend to conclude, and then, my lord, I'll take 2 minutes. If my learned friend is done.
Then, my lord, in that even, my lord, sees all the prayers.
Let him, my lord. Let him. He wants to.
Is there. Whatever is there is there.
There's there, my lord. So no prayer on the similar lines as to what Mr. Bagh is now praying for at the bar. This is, my lord, clear.
My lord, may I rejoin, my lord? Very briefly, my lord. Can you take a prayer B at page 19, my lord?
No, let us confine yourself with this thing.
I'll quickly indicate, my lord, what my learned friend is saying that
There are 6, 7 prayers.
Can you take a prayer B?
Prayer
Nothing
B.
else. Prayer B.
Yes.
A perpetual injunction to be issued restraining respondents and each of them by themselves or by their relatives or friends or employees or agents or assigns or otherwise whosoever for giving any effect or further effect to the probate of 2011 for any purpose or under any circumstances whatsoever. I pause here, my lord. This is the prayer that I'm praying for right now because, my lord, with this prayer, I'm not asking for molding of any relief. This is the prayer, my lord. All that they are seeking to do, be it, my lord, sale deed, be it, my lord, acting upon the sale deed, be it any act post 2011 is covered by this prayer. I'm not asking for molding of reliefs, my lord. If this, my lord, to the effect is granted, my lord, till the matter is heard out, Because, my lord, this should be read in conjunction with, my lord, kindly take prayer E at the same page, page 19, prayer E. Perpetual injunction, do issue, it's very similar, my lord, not to transfer, change nature, character, create third-party rights in this property. That's, my lord, prayer E. With this, the ad interim relief, prayer F. So at this stage, I'm praying for prayer F read with B and E. All that I'm praying for, my lord, because today the fraud perpetrated by my learned friend has to be considered on the basis of two admissions. One, that we are in possession.
No, this is going outside
Please,
the ambit of
please,
interim relief, my
please,
lord.
please.
This
You
is
have
on account of
completed.
merits, my lord. Then I'll
He has
I need to
promised
come
me
back.
that he will not interrupt
For
me.
this, I need to
My
put
lord,
on merits, my lord.
he has promised me.
Because his
My lord,
presenting interest, my lord,
one is the.
had been a consenting party. He's
I'm
right.
sure my
Let us
learned
see
friend
this,
is.
let us see this.
All that I'm praying for is possession has not been disputed by them. Second, they say it's a sale. I go by his case. Even if it's a sale, my lord, it's an undivided share, half share that they are contending. I am praying that cannot be acted upon because of prayer B, which I'm not praying for. And if it's an undivided share, which they have transferred, at this stage, Lord, they can't dispossess me from the property. All that I'm praying for is a stay in such lines till the matter is heard out. If it's a completed, Lord, we can come back in November. We can argue whenever your lordship
Record
pleases.
an order.
Others will be thrown out.
Learned
That's the only.
counsel for the applicant and learned advocate for the respondent. You are respondent?
Both the respondents, my lord.
Both the respondent.
Husband and wife, my lord.
Respondents, executors.
No, my lord. Respondent number 2
Yes,
was the attesting witness,
yes,
and the respondent number 1
yes.
was the daughter of the beneficiary.
Okay, both the appearing for the respondents. Heard learned counsels for the parties. This application GA3 of 2025 is moved with a prayer for revocation of the grant of probate dated 1st October 2011 by this honorable court, PLA number 27 of 2011, within bracket, in the goods of Joel Chinna Swami, David, bracket closed. The affidavits to this application is exchanged and the matter is being heard on merits. As the hearing of this matter cannot be completed today and more time is required to conclude the hearing, and in the meantime there is intervening puja vacation for a long period, learned counsel for the applicant submits that the applicant be protected by an interim order of injunction by restraining the opposite parties from selling or alienating the property which is bequeathed in terms of the alleged will. Stop. Learned advocate for the opposite respondents submits that the half share of the bequeathed property is already sold.
Undivided half share.
Bequeathed property which being undivided is already sold on 5/5/2025, and there is no scope of any interim order restraining sale of the undivided share of the property. Upon learned advocate further submits that the interim order which was obtained by the applicant in a title suit being
662, I guess.
662 of 2024 before learned Civil Judge Senior Division 4th Court Alipur was vacated by the said learned court, and the applicant, after waiting a long period, did not file this application for revocation of the grant of probate, but just after the undivided property was sold, the applicant came to file this application for revoking the grant of probate at such belated stage. Stop. Thus, on the grounds of delay, the interim order prayed for by the applicant should be refused. Upon perusing the petition, it appears that it is an admitted position that the property, half share of the property, which is disposed by a deed of sale, is in the possession of the applicants. It further appears that when the order of vacating the interim injunction was passed by the learned Civil Judge Senior Division 4th Court Alipur, there was no pendency of the application for revoking the grant of probate. Considering the fact that the property bequeathed was an undivided property, and it is only the shares of the undivided property is conveyed and the possession is not handed over, in the interest of justice, it would be reasonable to protect the possession of the applicant in the said property. Thus, let there be an ad interim order in terms of prayer B and E of the notice of motion dated 4th day of July 2025. This interim order shall be for a period of 3 weeks after Puja vacation. Let this matter appear 1 week after Puja vacation.
Very deep.
One more,
Yes.
it records that there is a submission that there was no prayer made to this effect in the application. No pleading and no prayer. Kindly indicate that.
Although there is no pleadings
That's the submission.
with as submitted by the learned advocate for the respondent with regard to the position being disturbed, this court is of the view bole oita diye debe.
Very deeply obliged.
Great.
Very deep.
Wait. I'm grateful.
Deeply obliged.
I didn't remember it. ঠিক আছে।
রোজগারটা ভালোই হবে
আরেকটু দু একটা ডাকুন তারপরে ইয়ে হয়ে যাবে।
Item number 32.
Yes. My lord, in item number 32, my lord, I appear for the
Today, yes, what is the latest development?
Development is.
Yes, let me see. Let me see the earlier order, আগের অর্ডারটা দেখান। Yes, so pursuant to the earlier order, only one bid has come.
No fresh bid has
No.
come.
You see, no, just a minute.
No new offer has come.
So this, no, just. Last
I am
order,
the bidder, my lord, on the first round of advertisement.
21/8, the order was passed.
22.
After that, no bid has come.
Pursuant to the first order of publication, your lordship, 3 bids came in.
No, that is there.
Yes, now thereafter, after the publication in the Bengali newspaper, no fresh bid has come. Now, your lordship, at this juncture, I would beseech your lordship to kindly direct the learned special officer to circulate the further report among the parties.
It is stated by the special officer that on account payment of rupees 50,000 was not handed over to him in terms of the order.
Kindly gives me some time.
No, why it is not done? You see,
I'll take instructions.
yes.
Plaintiff is concerned, plaintiff has came to hand over the check.
No. Total amount is 50,000.
But your lordship kindly envisages the situation.
Yes.
There are 2 sets of parties, the defendants and the plaintiffs. Both
So
will
both
hand
of you,
over.
total, both of you should hand over this
Yes,
50,000.
the total will come in 2 parts.
So you are ready and willing to hand over.
Yes.
Even we are ready and willing. There might be some glitches, your lordship. My learned advocate on record is not present here. Your lordship kindly keeps it any other
So
day.
I
In the
can-
meantime, we will handle.
I can direct circulation, and let this matter appear after vacation, or thereafter it can be decided whether fresh publication should be made or not.
Yes,
In the meantime, if you can arrange for this thing purchase, that you can arrange
Grateful.
by your own means, if you can arrange to come on the next day.
Now, my lord, we have already put in our bid, and it appears from your lordship last order, my lord, that perhaps my client is, my lord, the highest bidder.
How
And
much
so,
are you ready and willing?
my lord, 60 lakhs had been my offer, my lord. That has been recorded.
Do one thing. If you can enhance a bit, okay, I can ask them to consider.
My lord,
that
they
there-
allows, my lord also records that, my lord, if we are enhancing the bid
if
for.
you can consider some 10-15% a bit higher, then I can ask them to consider.
Very
Instead
well,
of-
my lord,
instead of directing further publication.
my lord may also consider my bid can be 65 lakhs as of now.
That will be decided on the next day.
No, I'll let
them come with firm instructions.
If they can enhance, okay, from 60
Yes,
lakh
they will
to
get the opportunity to enhance. Your
instead,
lordship,
instead of directing publication again and again.
Your lordship, your lordship, that we being the co-owners, we are being the co-owners, the co-sharers, are in a position to decide, your lordship, whether we want to go for the publication or we want to sell the property to him.
Yes,
My
record
learned
an
friend
order.
client.
So far as my lord, GA 23 is concerned, I have filed AO.
Today, it's not appearing, your lordship.
Yeah, 23 for what?
It's not appearing today, your lordship.
That application has not been listed, my lord. That has been taken out by the tenants.
Bringing this up, I don't know. It's not there in the cause lead. My lord.
GA 23 is for what purpose?
It's another application not related to the sale.
Yes, record an order.
May I return the party?
No, I think on the last occasion you took it back.
Yes.
So keep it with you. Learned advocates for the parties are present. Hard learned advocates for the parties. It appears from the report of special officer that pursuant to order dated 21st August 2025, no new purchaser has come expressing their offer to purchase the suit property. Thus, this matter stands adjourned till 10/11/2025 for further orders. Learned advocate who has learned advocate for an intending purchaser who has submitted the bid submits that till
Malad,
today.
Malad has
You are the
record
intending purchaser.
the first round of advertisement, Malad. Yes.
Learned advocate for one of the intending purchaser who is present in court submits that till today his client has submitted the highest offer and his case be considered. Stop. In the facts and circumstances, the learned advocate for the intending purchaser is requested to intimate his client with regard to further consideration of enhancement of the purchase price so that the existing parties may take a decision as to whether they will accept the offer of the intending purchaser or to go for a fresh auction.
Grateful.
Malad, let there be also a direction on the owners to consider the further offer which is being made. No, well, let that be recorded also.
The event the intending purchaser is ready and willing to enhance the purchase price, the same should be communicated through the learned advocate to the learned special officer and also to the parties. Learned advocates for the parties.
Grateful.
Grateful. Great.
এবার 12:30 ফিক্স ম্যাটারটা কল করে দিন।
My lord, next matter, my lord, it will take, my lord, 2 minutes time, my lord. Next matter, item 33, my lord.
Item 33, call 33.
Item number 33.
For the defendant.
My lord, this matter, my lord, I am for the defendant. I have taken out an application, my lord, for directing the plaintiff, my lord, to give inspection of the document because judge's proof of document also not available. They subsequently made the, my lord, judge's proof of documents and my lord, erstwhile advocate, he was expired suddenly, my lord, could not take inspection, though there was an order in fact. But they could not produce any document to show that inspection has been carried out. That's why, my lord, the in-cause prayer, my lord, kindly direct the plaintiff, my lord, to give us the inspection of the document, my lord, so that we can defend the suit, my lord.
But may this
But they didn't file any opposition, nothing of the kind. They didn't take any steps in this matter, my lord.
has been going
Time
on,
and again, matter is appearing.
this issue of taking inspection by the defendant has been going on for the last 6 years. But as per my instruction, they had taken inspection, but my learned senior friend is disputing that. Well, let us admit that no inspection has been taken. Lordship will direct, will also record that both the documents filed by the plaintiff and the defendant would stand denied by each other, and we would prove them in trial. Otherwise, but this inspection and discovery is going on for the last 6 years.
When are you willing to take inspection? I shall record.
My lord, kindly record next week, any day, my lord.
No, you tell the court will record this date. You and your client. When will you take that inspection? I shall fix a date.
Kindly fixes our date then.
Date and time also.
My lord, fix it, my lord, then, my lord, 27th, my lord, 27th.
27th.
25th, my lord, 25th, my lord, 25th.
25th.
My lord, 25th September, my lord, at 5 p.m., my lord.
Okay. Yes, record an order.
Now, my lord, plaintiff is, my lord, whether plaintiff is able to give the inspection on that date, my lord, let them have it answered.
Learned advocates for the parties are present. It is submitted by the learned advocate for the defendant that ও তো চেম্বারে ওরা চেম্বারে গিয়ে নেবে এখানে learned advocate for the parties are present. It is submitted by learned advocate for the defendant that he has prayed for taking inspection of the documents of the plaintiff for which no inspection was offered.
Inspection offered, not taken. I have letters on record.
Learned advocate for the plaintiff disputes the same and submits that the inspection was offered but was not taken by the defendant. Stop. And further submits that his client is ready and willing to give offer for the inspection. In the facts and circumstances, the matter stands adjourned till 3/11/2025.
My lord, 1 week after reopening, my lord.
Yes, 3/11/2000.
Very well, very well, very well, very well.
At the suggestion of the parties, the date for taking inspection is fixed on 25/9/2025 at 5 p.m.
At the office of the plaintiff's
chamber
advocate.
of the learned advocate of the plaintiff.
Grateful.
But this direction may be
No further notice will be required to be issued in this regard.
my lord, and my lord kindly makes this direction peremptory and
This direction is peremptory, no further opportunity will be granted.
and my lord kindly also records on the returnable date on 3rd November. My lord, it's for fixing of framing of issues. My lord, I've brought my suggested issues today.
Then, my lord, third, my lord, we shall make appropriate submission. My lord, let it come back after inspection. My lord, kindly do not, my lord, make any specific order today, my lord. Let this matter appear, my lord, then you will pass on.
Appear under the heading to be mentioned on 3/11/2025.
Grateful, man.
My lord.
Grateful.
My lord, grateful.
নামটা আমাদের নামটা ওখানে দেওয়া আছে।
Fixed matter at 12:30 p.m. Item number 4.
My lord, this is my application for execution. Well, this is my application for execution. The examination of judgment debtor is complete. I have just got the depositions. Kindly keep it some other day. I'll pray for appropriate orders. They have admitted properties are there.
Yes, record an order. Learned advocates for the parties are present on the prayer of learned advocate for the degree holder.
In the next week,
I'm keeping it after vacation.
my lord, they have admitted there are some properties.
Let this matter appear on.
My lord, be pleased to keep it after.
No, they might alienate the property.
There is an interim order probably there.
No, there's no interim. There's no interim order. They have, my learned in his deposition, he has admitted that there's a land worth 50 lakhs. He has admitted, and there are some shares of the company which is still in the name of the company.
Okay, let it be after vacation. In the meantime, let there be an interim order not to alienate.
Alienate the property admitted in the question number. May I indicate the question
Yes.
number? Yes. The question number.
No, what is the property?
Constituency value of land, 50 lakhs worth of land, which is at Poilan. He has admitted.
Okay, in the meantime, learned advocates for the parties are present. Let this matter appear on 10/11/2025. However, during this, there shall be an interim order restraining the judgment debtors from alienating,
land at Poilan,
transferring or parting with possession of the land at Poilan.
And shares
Lands at Poilan, which area? Poilan district?
South Chowbish Pargana.
Poilan district, South 24 Parganas.
No. South.
Yes, Poilan South Chowbish Pargana.
Yes, South 24.
District, South 24 Parganas. And shares?
And shares in Kulti Townlet Homes Private Limited.
And shares in Kulti Townlet
Homes Private Limited.
Homes Private Limited.
Yes, these two.
For a period of 4 weeks after vacation.
Deeply obliged.
Item 34.
Okay, not today.
Lordship, I appear for the plaintiffs. Lordship, the last occasion, Lordship had directed the matter to appear on 17th of September. It's wrongly appearing today, Lordship.
Oh, it is due to appear on 17th?
17th of September.
Record order, let this matter appear on 17/9/2025 as
Or,
earlier directed.
Lordship, for hearing of the application.
Let this matter appear on 17/9/2025 as earlier directed for hearing of the application GA 22 of 2023.
Lordship. Grateful, Lordship.
Item 36 and 37.
36 and 37, Lordship would recall this is the GA 25-26 Tata consumer Tata Tea matter where the shares were there and
Mr. Bose,
Mr. Tilok Bose was on the other side, Lordship.
anyway, today you see, I'm not taking, you see, there is a request also.
Very well, my lord. Only one thing, my lord, there is a chance that tomorrow, my lord, the determination may change. Only one prayer.
Just
Lordship,
not today
let it-
only.
No, Lordship may mark it as part heard. Lordship has
In
heard.
the absence of the other
It's
side,
not an,
how
it
can I
is
do
not
that?
an adverse order, my lord.
That
It is not an adverse order. Only in case an order which is adverse to the parties, Lordship. I do not think, my lord, this will be because Lordship has heard them entirely. I have argued GA26 entirely. GA25 I have started. Lordship, I shall only cite few judgments and they are supposed to rejoin.
Okay, item 36 and 37, please record an order. Learned advocate, Mr. Ali, learned advocate for the plaintiff is present. On the prayer of learned advocate for the plaintiff, the matter stands adjourned till
I'm not praying for adjournment. Anyway,
29/11/2025, as this matter was heard on different.
Lordship keeps it tomorrow, my lord. Lordship keeps it tomorrow, but Lordship
Then
kindly
why
mark
part
it
then
part
why-
heard.
You see, if I have to make it part heard, I have to pass on. Yes, Mr. Bose has come. Yes, are you in a position to argue the matter?
I have finished. Has he finished? He was
No,
addressing.
I'm not finished. I
Then-
was arguing. They were not here. So
No,
Lordship
you were
said-
not
No,
here.
no,
That's why
I-
I wanted to adjourn the matter.
No, but I am here. I mean, they are finished. I will give you a note. I mean,
Then you conclude today.
it's up.
Lordship. I was praying in the meantime that let it be marked as part heard because tomorrow the determination may change.
That is for, I mean, how can I, whether it's your law, I mean, I have no objection. I mean, anyway, I mean, determination will change. I am not.
May. We do not know.
Only, it's going to change. I mean,
No, because you see, if I adopt this practice for you, so many requests will come. So all other matters,
With respect to Lordship,
the matters which are hard, the matters which are hard at length, and it is at the verge of disposal, those matters should be made part of.
This is at the verge of I'll conclude today, my lord.
I'll
Anyway,
give a reply.
Conclude it.
May I quickly recapitulate GA26, my lord, which was recapitulate GA26, which was the demurrer application, and GA25 are
Recalling application.
recalling application. The demurrer application, Lordship, their only point was that the suit is bad in law because no writ of summons had been served with respect to the various amendments which has been carried out by the plaintiffs, and thereafter no writ of summons. So this suit has become dead suit. Lordship, I have indicated on the last occasion, no law has been cited that for non-service of writ of summons, it becomes a dead suit. On the contrary, Lordship, I have shown that we had, on all occasions, my lord, we had served them the amended plate to the parties, including the defendant number 6, and they have received it by endorsing their seal and signature, and they have raised no dispute from 1997. So one of the cause of action, which is, if at all, of 1997, is being exercised today, if at all, saying that this has
Give the
become-
affidavit in opposition.
Good. Affidavit opposition to GA26, Lordship.
Yes, this is GA26 para. Which para you are relying of your opposition?
The opposition, I have stated in my opposition in para 10,
Yes.
page 9.
Yes.
The learned advocates on record of the plaintiffs had always served a copy of the amended plea on the defendants, including the applicant hearing, and at no point of time any objection with respect to non-issuance of writ of summons was raised. It is a common practice of this honorable court that issuance of writ of summons is waived. The conduct of parties also demonstrates the same. Since the present suit is very old, plaintiffs do not have all the application and the correspondences by which the amended plaint had been served on the applicant. However, the plaintiffs had got hold of some of the covering letters under which the amended plaints were served on the applicant. Despite notice and knowledge, no issue for dismissal of the suit had been raised by the applicants admittedly since 1996. Now, my lord, you will see page 17, page 35. Apropos this. The covering letter addressed to Victor Moses of 17 May 1997, and as you will see in terms of order dated 7th May 1997 passed by His Lordship the Honorable Justice, we send here with copy of the amended plaint upon you. Please acknowledge receipt. Etan and Company was the solicitor then for the plaintiff. Subsequently, page 36, the next page. This is the same letter which has been served directly on the defendant number 6.
Yes.
It's also by post, you will see the endorsement at the bottom. Not denied. These are not denied even by their affidavit.
In the reply, affidavit in reply.
I shall show the affidavit in reply. Page 37 at the bottom, Tata Tea Limited, through their advocates, Mrs. Victor Moses. And there is a endorsement of receipt just beside that. At the bottom of page 37,
Yes, Tata Tea Limited.
And Victor Moses have received. And what is the content of this letter? Lordship will find that from page 39. Page 39, in terms of order dated 24th April 2014, passed by His Lordship the Honorable Justice, I send here with copy of the amended plaint upon you. Please acknowledge receipt. Again, no objection from 20. This is a letter dated 2014. No objection. And thereafter 2018. Page 40. In number 6, Lordship will find Tata Tea Limited through their advocate, Mr. Victor Moses. And again, an endorsement of 2018 also. The content of the letter is at page 41. Yes. I am acting on behalf of the plaintiff in the above referred suit. If finding includes a copy of the amended plaint filed in the suit, kindly accept copy of the amended plaint and acknowledge the receipt of the same. Then what you will see page 42. It is not that they received and they never appeared in the suit. But I have got hold of one order in which I can show that defendant number 6 was represented in way back in 2013, 28 February 2013, page 42.
Yes, page 42 is there.
And
defendant number
defendant
6.
number 6, such and such advocate appears. So, not only they received the copies of the amended plaints, they appeared in the suit, they contested the suit. From 1996, no objection raised with respect to this writ of summons. It has become a dead suit. Suddenly, in 20
Regarding that schedule of this property, it was probably the schedule of the property that is
So it
of
remains
the suit
unamended.
property.
That was the last submission
That was
made
in the
on
name
the
of the
bar.
dead person, apparent on the face of the record.
That submission, my lord, I will say that that is a submission made from the bar. No pleading.
The question is, suppose it comes to the notice of the court that this schedule is in the name of the dead person. How do you explain?
Schedule in the
Name of the schedule of property, that is in the
schedule of property.
yes.
These are shares.
Share. That is movable property.
The shares, and it was lying in the name of Mr. X. Mr. X passed away, leaving a will. Mr. X was substituted by his wife, the defendant number 3. The contention is because the schedule was not amended, saying that it should have been named instead of Mr. X. It should be named as the defendant number 3, his wife. Because of non-amendment of the schedule, the entire suit becomes bad. I fail to understand how the suit becomes bad for the schedule. But it's not a document, Lordship, on the basis of which the merits are decided. This is not a document, and first, number one. Number two, Lordship, this is not the stage, Lordship, to hold that whether at all for non-amendment of schedule or for non-application for transmission of shares, the entire suit will become bad because the shares will just completely vanish because the schedule has not been amended. This is not the stage. There is no question of mini trial. The Supreme Court has said, on many various occasions, there is no question of mini trial. You have to decide after trial all these issues, whether and any amendment and lordship for non-amendment. These are all curable defects. I'm assuming this is the best point that they have, that the schedule is incorrect. But it is not the case that when Mr. X was alive, then the schedule was incorrect. It is not their case. Well, it's only a curable defect. If I amend it, the lordship feels that I need to amend that schedule, so I shall amend it. And all this without any lordship pleadings to the effect. Suddenly, the last day, and one submission that because of non-amendment of the schedule and non-application for transmission of shares in the name of the deceased, in the name of the substituted defendant, the suit becomes bad. Again, no law has been cited. Not a single judgment for this proposition that if I write it, so say for example, if I write it the schedule that premises number such and such belonging to the plaintiff number 1 and plaintiff number 1 died. Just because I do not substitute the schedule, the entire, I have to substitute the cause title, I have to substitute the schedule, only then the suit is maintainable. There is no such law which has been cited that both has to be amended at the same time. The second again submission, which was also lordship from the bar, was that the name of the defendant number 6 shall be expunged. That was the last submission which was made. Again, my lord, no pleading, no law has been cited that if the schedule is remains unamended or schedule remains in the name of the predecessor of the party, then the suit, then the defendant is required to be expunged. There is no paragraph of the plaintiff has been cited to show that there is no cause of action against the defendant number 6. In the several paragraphs, lordship, I have said the cause of action which I have against the defendant number 6. And the defendant number 6 is appearing, contesting, has chosen not to file a written statement. And in fact, my lord, I have shown the affidavits which says that I do not want to get into the disputes between the plaintiff and the transferees, whatever the Honorable High Court will say, I will transfer the shares in favor of that person. If it is the plaintiff, I shall transfer the shares in favor of the plaintiff. If it is the defendant number 1 or the transferees of the defendant number 1, I shall record the shares in the name of the such transferees. So that is their stand. And now they have become an active defendant and trying to get the suit of the file. That is, I do not understand their stand. So again, my lord, no law has been cited. It is all because non-service of writ of summons makes it dead suit. One has to just believe it.
The twofold submissions, that is, one is the non-service of summons and the other is that schedule aspect.
No cause of action.
Yes, with
As against me.
With regard to GA 26.
Yes, sir. No cause of action as against me. That's two submissions. Absolutely right.
GA 25 is a separate.
GA 7 is on the
Only
question.
recalling.
I never got an opportunity to file a written statement. They have shown of the subsequent amendments. The service was never by the sheriff. Like a summons comes that on such and such date, this is the amended plaint. Within such and such date, you will be entitled.
That is 25.
That is 25. These are the short facts are huge, but I mean, point of law is
no. This is the question of law. GA 26, GA 25 scope is limited.
Is limited on the ground of service of summons. Whether I have asked for recalling of the orders. Yes. Whether I ought to have been.
You ought to have been heard or not.
Yeah, no. Opportunity ought to have been given for service of summons, and they are saying that this showing some prior service was made by some letter. That is not service.
This is GA 26, okay?
Yes, 26. 26 is cause of action.
Lordship will see their affidavit in reply now. Yes. How they have dealt with paragraph 10.
Affidavit in reply to the GA 26, sir. Yes, para.
Para 10 they have dealt with in paragraph 17, page 9.
Yes.
What else? The statements made in 1 to 14 of the affidavit in opposition, 7 except those which are matters of record, are denied and disputed in its entirety. And then from 17.1, Lordship, they deal with paragraph 1 to 14. But I should show the relevant paragraph, which is paragraph 17.16 at page 30.
Yes.
21.18.
Yes.
It is denied that although applicant's hearing had alleged for the first time in the present application that despite several amendments have carried out in the present suit, they have not received any summons pursuant to such amendments. So the fact that they are alleging for the first time, that has been denied. It is denied that such issues were not raised until the petitioners had filed the application for contempt. It is denied that admittedly the amendment took place in years 1996, 1997, 1998, 1999, and such that all these years, and the applicants have never raised any objection with respect thereto. They also deny that. These are bold denial. It is denied that an advocate on record of the plaintiff has always served the copy of the amended plaint on the defendants, including the applicant's hearing, or at no point of time any objection with respect to non-issuance of writ of summons was raised. It is denied that it is common practice of this honorable court for the issuance of writ of summons is waived. As alleged all, it is denied that conduct of the parties demonstrate the same. It is denied that despite notice of knowledge, issuance of dismissal of suit has been raised by the applicants since 1996. it is denied that the applicants also did not ask for recall of any order for amendment of the plaint as alleged or at all. Well, these are all bold denial. The statements made in the paragraphs under reference clearly indicate that the plaintiffs also admit the facts of not having lodged the writ of summons pursuant to several amendments which they carried out. There is no question of waiver of requirement to issue writ of summons unless and until such waiver is expressly made by a party, which in this case is absent. As such, the plaintiffs are under an obligation to lodge and cause issuance of writ of summons upon each amendment being made to the plaint. The failure to do so is now an admitted position, and in the absence of any basis to do so, the same cannot be condoned. And as such, the present suit is liable to be dismissed on such ground, so far as the present application is concerned, in view of the facts and circumstances and especially admission for non-issuance of writ of summons consequent to the respective amendments. The plaintiffs are not entitled to the amendment which they have sought by means of the amendment application of GA23, and as such, the order passed in respect of the amendment application deserves to be recalled, and the amendment application deserves to be dismissed. The defendant number 6 also applied before the Honorable Court for dismissal of the suit. The said application has been registered.
So this is pending dismissal of the suit, GA26.
That's GS26.
Or GA, no, GA26. This is GA26.
That's.
No, what application for? Oh, this
That
is
is
GA26. Right.
My lord, reply.
GA25, that is.
My lord, fortunately, now under the Arbitration Act, they have said it's only statement of claim and statement of defense. These are the pleadings. Reply, when in the lower court also, it comes as reply. What's your reply? Saying that it's a reply actually of the defendant. This concept of reply.
That reply means reiterate of the opposition. Reply means to the opposition.
No. Reply is to the petition.
Yes.
I repeat and reiterate. So where the concept of reply came, I am not. It's a practice of the Calcutta High Court, or certainly not in the lower court, because in the lower court you.
It ends with written objection.
Written objection. You say you file reply.
Sometimes this procedure is also adopted.
Even arbitration, yeah, we file rejoinder, sir, rejoinder. The act doesn't.
Some cases, miscellaneous cases, this procedure is adopted.
That's a. So, it's a matter of procedure. So, for example, you raise a counterclaim in a opposition. You have to file a reply to counterclaim.
Yes, that is a written statement to the counterclaim.
Now, arbitrators are also confused. Arbitrators are now giving direction. Yes, no question of rejoinder, because that's right. You file only to the, if you have made a counterclaim, reply to the counterclaim. And that will be treated as rejoinder. We invented the concept of rejoinder, sir, rejoinder. These are all, where it came from, I do not know. But it's there. This is on a lighter note. I'm saying this.
So this is there, 17.26.
So 17.26, they have denied that they have filed whatever. But in their reply, what I wanted to show is they do not deny that they have not received the amended plaint. And they do not deny.
What they deny is they have not waived the service of the writ of summons. That they have not waived. That is their bone of contention.
Waiver, Lordship. That is why, my lord, one of the orders which I showed in the recalling application, Lordship, there was an order that writ of summons, service of writ of summons is waived.
Anyway, that's a different issue. But the defendant has not expressed the right to waive express the right. So they have not expressly waived the service of the writ.
Not expressly waived.
This is their contention. They are not disputing the service of the plaint.
Well, after service of Lordship, whether this, I'm assuming, Lordship, in 1996, I have served in the first amended plaint. They do not take any action there. In 1997, again an amendment was made. They do not take any action even then. And thereafter, throughout the years, around 9-10 amendments had been made. The last was in 2017. They do not raise any
So anyway,
objection.
this is the application when 2024.
This is the
Both are of 24.
2024 application. After 2023 amendment was allowed, saying that even the orders of after 1996, since no writ of summons were issued, so the suit has become dead. There has to be some basis for this. Rashid, the first writ of summons, Rashid, I understand, Malab, for there are judgments. The first summons to be served on the defendants, that has to be done. Otherwise, that is because the plaintiff has simply filed the suit and not taking any step to take the suit further. But here in this case, all they are receiving the amended plaint. They are
That
participating.
is, you see, so far the service of the first summons upon the defendant is concerned, that so strict compliance to that is necessary. That is more serious in nature than the subsequent one.
And even
First one is
even
definitely a serious view has to be taken.
for that.
Yes.
But even Lordship, in those situations also, Lordship, I have seen applications filed in this court, application for dismissal filed for non-issuance of non-lodging of writ of summons.
That's a different issue.
And Lordship, just cost is
So this
imposed
view,
and it is
the
allowed.
serious view is taken with regard to that,
Of course,
compared to the
because-
subsequent one.
Because the suit is not proceeding. One has filed the suit, to keep it languishing, or some malafide motive.
The defendant should not be kept in the dark and thereafter on one fine morning taken by a surprise.
Right.
Yes.
But here, my lord, the parties are served with the amended plaint. They are participating in the proceedings, and not only that, my lord, they have never raised any objection with this.
Anyways, these are dealt with in your reply, in your opposition probably, you have dealt with,
Yes.
supported by your annexures. So regarding points of law, you come with your written notes of argument?
I have filed my written notes.
You have already filed?
No, I'm sorry. I have prepared my written notes.
So, yes, when can you conclude?
Yes, any day, which.
After you conclude the written notes of arguments after being exchanged,
Correct.
be filed.
Yes. My lord,
See, because if you want, you can conclude tomorrow. Or after at 2 p.m. you want to continue.
But GA25 I have not started.
GA25?
It is only GA26 which I said. GA25 is there where I shall show that the application is not maintainable. Because
then you
recalling of 10 orders they have asked for, in which they participated. So,
recalling of 10 orders because
Otherwise,
no
you see, I have
opportunity to file
I
written
have to deal
statement.
with them separately. First of all, I take this application.
finish
I have to
GA26.
then I have to conclude hearing of this, pass an order, and then take up this matter.
No, my lord, I have made submissions in both. He is giving reply in both. I will make a composite.
No, but can you conclude it before vacation? That is the thing.
I don't think we have the dates because he.
Tomorrow, Lordship keeps.
No, he make. I need some time to give
The reply.
reply.
Then Lordship kindly makes it part.
Because after
Yes, that is
after
no issue.
reply, then you have to file your written notes
Of course.
अच्छा দেখুন তো ये বুধবারে কি সময় আছে
Just before the.
You see, 2 weeks only left.
Yes.
That's the problem.
So if you just conclude the hearing, it would be better.
No, if your lordship insists, yes, why not?
আচ্ছা বুধবারে কি 10:30টার সময় কোনো আছে?
But next week would it be better if I complete my reply?
আচ্ছা শুক্রবারে 10:30টার সময় দেখুন তো
Friday, my lord, the appeal court has fixed, and one before Justice Bhattacharya also.
সোমবারে দেখুন তো
Yes.
22 তারিখ
I was suggesting
10:30টায় কিছু ফিক্স করা আছে? You see, I am unable to take it up at 3 p.m. because at 3 p.m. I have to take appellate side matters.
Oh, okay.
Huh?
But 2 p.m. no?
PM also, but some matters are already fixed. আচ্ছা ওই দিন কি দুটোর সময় কোনো ফিক্স আছে? 22 তারিখে নেই কোনো, আছে দুটোর সময় ফিক্সড. I'm keeping it at 10:30 on Monday. 10:30
for whose submission?
No, Mr. Ali will continue.
You
Yes, with
No, no, I thought he was concluding tomorrow.
If it can be kept tomorrow.
Yes,
তাহলে
I'm saying only for my reply. So
কালকে
that
দুটোর সময় ফিক্স ম্যাটার আছে।
Tomorrow keeps it in regular date like today.
কাল দুটোর সময় ফিক্স ম্যাটার আছে। First half actually there's the
so
chamber.
tomorrow, day after, let him complete. Even on Friday, if he completes.
বুধবারে 10:30টার সময়। Wednesday you have some difficulty.
Man, all these matters are fixed. No,
Wednesday.
no, but he can do this.
I have something.
Wednesday, whole day.
Well, he has to finish first. Because Monday, if you were fixing, I can complete. I will take what, 50, 20, 30 minutes.
Thereafter written notes.
The written notes, I will be come ready. No, once he finishes.
So 22nd you can conclude. 22nd.
Yes, I can conclude, but he has to first complete.
I'll conclude, Lordship.
So that is not a complicated. GA 25 is not very complicated.
No, it is simply.
Acha, ছেড়ে দিন। So GA 20, this matter I'm keeping it 10:30 tomorrow.
Both.
Yes, and 22nd.
No, keep both.
Yes, both the man.
Man, he won't complete.
Oh, 22nd.
Then, no, if he completes immediately, I can't.
No, how much time you require for this GA 26?
25.
Another 10 minutes to cite the judgments.
And GA 25?
25 will be another 15.
Acha,
20
reckon.
minutes.
Learned advocates, counsels for the parties are present. Hey,
so
learned counsels for the parties are present.
Well, as per his convenience,
Yes.
please give time this week, anytime.
Hard learned counsel appearing for GA 25 of 2020, GA 26 of 2024.
20.
Hearing could not be concluded. Thus, this matter be fixed on 22/9/2025 at 10:30 p.m.
My lord, your lordship cannot fix for his completion anytime this week. Otherwise, then 22nd.
No, I can keep it on Friday also, this Friday also.
Please keep it. But plus, do not ask me to complete.
Yes. So, let this matter appear on 19/9/2025 at 10:30 a.m. Keeping it at 19/9.
Yes, for completion of arguments of the plaintiff.
Yes, definitely will reply.
Yes. But for reply, I'd be besieging your lordship for Monday or Tuesday, whenever.
ওই দুটো ম্যাটারই একই অর্ডার করে দেবেন, ঠিক আছে?
So lordship has fixed it this Friday.
Yes, this Friday.
So it's understood that he will.
Rally to conclude.
Lordship keeps it part.
Acha, this matter is treated to be parted.
Both applications.
দুটোতেই করে দেবেন, হ্যাঁ? This matter is treated to be parted. Similar order. Single order করে দিচ্ছেন, ঠিক আছে? The single orderই থাকবে।
Your Lordship, the next matter, item number 38, I am for the plaintiff. Your Lordship, instead of not today, kindly keep it on Thursday, Your Lordship.
Okay, not this week. Item 38, not this week. Fixed. আচ্ছা জাস্ট এ মিনিট, ফিক্স ম্যাটার লাস্ট কত অবধি হয়েছিল? আচ্ছা ঠিক আছে, ফিক্স ম্যাটার।
Item number 2, fixed at 2 p.m.
I appear for the plaintiff. Well, this is an application taken out by the defendant for leave to cross-examine my witness. Well, I had directed affidavits to be exchanged in this matter. Well, may I file my affidavit in opposition? We are slightly behind time, and the affidavit in reply also has been served upon my client. So the matter is ready for hearing. Well, will kindly, since today, well, they're not appearing, I don't stand in the way. Well, will fix any date for hearing. Well.
Yes, learned advocate for the plaintiff is present. Let the affidavit in opposition filed to GA6 of 2025 be kept with the record. As affidavit in reply is already served upon the learned advocate for the plaintiff, let this matter appear on 23/9/2025. Let it just remain instead of making fixed.
Well, can keep it tomorrow itself. Let the matter remain in the list. My lord can direct.
I'm keeping it at 23/9.
My lord. My lord. And my lord can also direct us to serve a notice if no. My lord, we'll also serve a notice upon the defendant.
Learned advocate for the defendant be intimated by notice.
Obliged.
Grateful.
Item number 3.
My lord, I appear for the plaintiff, my lord. This is that matter regarding the transfer, my lord, of the matter to the commercial division. We had filed a written notice.
GA7.
My lord.
In this GA7 affidavits are filed.
Yes, yes, yes. My lord, your lordship was hearing the suit. My lord, we had taken a point that in view of the judgment of the Honorable Division Bench, T. Thompson, so this suit requires to be transferred before the commercial division of this Honorable Court, my lord. Your lordship had heard the matter. Both the parties have filed their written notes of argument, my lord, in this matter.
Okay, record an order.
Only one thing, my lord. What has happened is, I have come to learn, my lord, that T. Thompson, in which the Honorable Division Bench presided over by Justice Shen, my lord, that matter, perhaps, my lord, a Supreme Court petition is about to be filed. I have come to learn from the learned friend who is dealing in that matter.
So I can keep it after vacation.
Yes, my lord. So that, because what happens is, if it is entertained and if there's a stay, then again there'll be a problem, my lord, to get it back transferred before your lordship. So if this matter can be...
On the basis of that order, that application order,
yes,
I've also passed other orders.
Yes, now the Mr. Soroshish Dasgupta was dealing with that matter here. The SLP has been finalized, it had been sent. So let us...
advocate for the plaintiff is present. GS7 of 2025 is ready for hearing. Let this matter appear on
We filed application.
3/11.
My lord, GA7 is not my application, my lord. GA7 is...
No.
In the hearing of the suit, my lord, we had come up with this point.
No, GS7. This application definitely is your, no, whose application
Well,
is this?
GA7 was their application under Order 7 Rule 11, which has already been dealt with by the Honorable Supreme Court, where it has been ordered that it is not pressed.
Right, Mr. Swanan
Yes,
his appearance.
yes, my lord. This is that matter. So before the
The
Honorable,
plaintiff.
yes, my lord.
Okay.
So GA7 is already dismissed, my lord.
Okay. Learned advocate for the plaintiff is present. Let this matter appear on 3/11/2025
Grateful, my lord.
at 3 p.m.
My lord. In the meantime, my lord, we'll communicate to your lordship whatever
Yes,
is in
learned
the.
advocate for the defendant be intimated by.
I will, my lord. Grateful.
Item number 4.
Okay, not today.
5.
Not today. আইটেম 4-5 এ তো অর্ডার হয়ে গেছে, বোধহয় কল হয়েছিল ফার্স্ট হাফে। অর্ডার হয়ে গেছে তো। হ্যাঁ কোনটা? আচ্ছা 6-7 তো কল হয়েছে আজকে। হয়তো তাহলে যেখানে যে আর তো ফিক্স ম্যাটার নেই, তাহলে ওই যেখান থেকে লাস্ট কল হচ্ছে তারপর থেকে কল করুন।
Item number 39.
My lord, in item number 39, I am appearing for the defendants. My lord, this is a partition suit. My lord, the partition commissioner has filed a report, my lord, in the first week of August. I would humbly request, my lord, kindly keeps the matter on the other side of the vacation. In the meantime, my lord, we will file an exception to the report.
But for the defendant.
Defendants, my lord.
Learned advocate for the defendant is present. Yes, you are appearing for? Okay, just let it appear next week. Learned advocate for the defendant is present. Let this matter appear on 22/9/2025.
We might need more than 7 days time to file the application, my lord. I was just humbly requesting if my lord could give us.
Anyway, you see, it is also pending for a long period. You take your chance.
Very well, my lord. I'll come back on Monday, my lord. Monday next.
Item number 40.
In this matter, I am appearing for the plaintiff respondent. Order 7. At the matter, Mr. Sumandar is appearing. And I am paying the matter.
No, this matter, Mr. Shumandotto is for the plaintiff.
It's for the plaintiff respondent.
Plaintiff respondent. Oh, and Mr. Gupta is for the applicant defendant.
It's applicant defendant.
It's applicant defendant. Yes, so I'll keep it after vacation.
And you make it on Wednesday. I had a talk with Mr. That.
No, Mr. Gupta will be available. Otherwise, no use of keeping it. Mr. Gupta had to leave station due to some difficulties. Okay, item.
17th,
Let it be next Monday.
Next Monday.
Learned advocate for the plaintiff is present. Let this matter appear on 22/9/2025.
For hearing, item number 41.
Okay, not today.
42.
Not today.
43.
43, Your Lordship, I appear on behalf of the degree holder. Lordship was pleased to appoint special officer in this matter. But since there's a resolution, Your Lordship, I believe my learned friend is seeking for an.
What is the order passed? Let me see. Yes, you are for? Judgment. Let me see the order, okay? Last of the order passed on the last occasion.
Decree of 2018 not satisfied till date. There's an intervening application as well. The state is also seeking to file an application.
Okay, today was fixed for?
Your Lordship, for Your Lordship to take up the report and Your Lordship, the intervening application.
So report is not yet filed?
Report has been filed, Your Lordship.
Okay, report is filed. So the report has to be circulated.
Lordship, that's also done.
So report is filed and circulated.
Yes, yes,
So
your
the intervening application has to be taken up.
Lordship, just one humble prayer. I know today, Your Lordship, I do not want to take this order in the junior's name. I will pray for it on the next date, because the special officers have found out a new bank account which is of the judgment debtor in paragraph 3 of their report.
So you'll pray for that on the next day.
Not the next day,
Anyway,
Lordship.
record an order. Learned advocates for the parties are present on the prayer of the learned advocates. The matter stands adjourned to next week.
On the prayer of the learned judgment debtor. Kindly records that.
Okay, learned advocates for the parties are present on the prayer of learned advocate for the judgment debtor. The matter stands adjourned till 23/9/2025.
Grateful, Lordship. Namdev.
Item number 44.
Lordship, I appear on behalf of the petitioner. We are
Petitioner plaintiff.
Yes, Your Lordship.
Yes.
Lordship, we are under witness action, but if Lordship kindly gives us a date, any day after the vacation for witness action, Lordship.
Yes. Record an order. Learned advocate for the plaintiff is present on the prayer of learned advocate for the plaintiff. The matter stands adjourned till 27/10/2025.
Grateful, Your Lordship. Lordship, for witness action.
Yes, it's under the same heading.
Under the same heading. Grateful, Your Lordship.
The appellate side matter. Appellate side matter কি এখন না 3টের সময় ইয়ে করব? এখন ইয়ে করে দেবো নাকি 3টের সময়? হ্যাঁ? কোথায় দেওয়া আছে তো? Immediately or at 3 PM whichever is there. ঠিক আছে কল করে
Item number 1.
So you have filed your written notes of arguments. Yes?
It was supposed to file today, but I have got it.
Copy is served upon the opposite parties, that is petitioners. Yes.
They have also not served.
They have not filed.
He was supposed to file today, but
That is, you are for the opposite party. So do you know whether they did? Acha, record an order, please.
Shall I file today? Or?
Yes, yes, yes. Learned advocate for the opposite party is present. Learned advocate for the opposite party files written notes of arguments. Let it be kept with the record. Let the matter be fixed on 17/9/2025 under the same heading to be mentioned for filing written notes of arguments by the petitioner. আচ্ছা এই সেটা তো পিটিশনাররা কি রিটেন নোটস ফাইল করেছে নাকি আদারওয়াইজ 17 তারিখে আমাকে বলে দেবেন 17 তারিখে টু বি মেনশনড থাকবে
Notes of argument. Argument be filed 15 September.
We were supposed to file.
Okay, regarding petitioner, what I am asking, petitioners whether they have filed or not. মানে both party.
Filed by September. Parties are able to file their written notes of argument. There are argument complete. The parties
আচ্ছা, মানে only filing written notes. দেখি অর্ডারটা একটু। Parties are present, parties did not survive. ঠিক আছে, মানে hearing is already concluded. আচ্ছা, let this matter appear on 17/9/2025 for filing written notes of arguments by the petitioner. Let this matter appear under the same heading to be mentioned. ঠিক আছে, তাহলে ওইভাবে। Yes, on day after tomorrow it will appear if they file well and good, otherwise it will be treated to be concluded. Not today.
3, 4, 5, 6, 7, 8, 9, 10. 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 9, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 2, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 5, 6, 7, 8, 9, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 2, 3, 4, 5, 6, 7, 8, 9, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 7, 8, 9, 100, 101, 2, 3, 4, 5, 6, 7.
Lordship, 107, I'm praying for a day's accommodation.
107.
107 along with 110.
107. Okay, 107 not today.
8, 9, 10.
Okay, 110 also not today.
7, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29.
ঠিক আছে।